of what we are seeing on the dailies, maybe not on the front pages, but we can see that the Law Society is fighting an order that has blocked hiring of private firms by state agencies. On the same page, I'm talking about the Standard, page 10, where there's a legal storm as the state has hired private lawyers in a 5 trillion shilling fund case. Now, this debate about the hiring of private legal services by state agencies has raged on for quite a while. And
Yes,
I'd like
indeed.
to get your stand on this because, yes, it is part of the loopholes where many people, even the Auditor General, has said this is where the government is losing funds. What is your take on it?
First of all, let me say that hiring private lawyers has helped the government save a lot of funds in high-stakes cases, like international arbitrations in the UK and elsewhere. And they have even hired foreign firms and paid them a top dollar because they realized what was at stake. So if the government just relied on their own internal counsel, they would not be able to match other organizations that take high stakes external legal counsel in international legal disputes in the UK, in the US, and elsewhere. Mm-hmm. Other governments also hire this external counsel, Queen's Counsel, and others to represent them because they are going to save a lot of money. So it's the same logic that even as the government lawyers, in-house counsel, work together with the external counsel in these international arbitrations, they collaborate because it is a joint effort. The internal professional and the external professional each has their role to play. It's the same in local disputes. Mm-hmm. You need a collaboration between the lawyers who work for these public sector organizations in-house and the ones who work externally. And if I can extend the debate or the discussion even beyond lawyers, when the government decides to build a road or come up with infrastructure, they have internal engineers in their organizations. But the actual job of the engineering drawings is done by the external engineers, and the internal engineers review. That's the same with accountants, it's the same with other professionals. So what we are saying is, it is standard in professional services to have your internal professionals who review the work of external professionals.
Standard senior counsel, the issue I think is about the legal fees that these lawyers charge.
Yes.
And apparently it would appear there are no standards when it comes to that. Some lawyers charge counties exorbitant fees,
yes,
even the IEBC, and that is what many people are complaining, that these things are rarely budgeted for,
yes,
legal fees. And then these entities end up spending too much beyond their budgets just paying private lawyers.
Maybe I can say 3 things very quickly.
And before you do that, I would like to invite Wakili Harrison Kinyanjui onto the set, because I'm sure you'd also like to contribute to this debate even as we continue this. Karibu sana Wakili onto the set. Yes, Senior Counsel.
Yeah, I would like to say 3 things briefly. One, I've observed the reporting, and the reporting also in the media has not been consistent. Because sometimes when public sector entities report on legal fees, they report on what the lawyers will earn and also the court decree. They put them together. So they call them legal claims. You assume all that money is going to lawyers, and it's just because the lawyers are the ones demanding money on behalf of litigants who have won decrees and court cases in the court. So if you scrutinize the report, some that have gone to parliament, that have been relied upon by the media, they keep mixing legal fees and also court decrees because they are part of legal. So they are projecting an impression which is actually not very accurate as to the quantum of legal fees. And there is need to revisit and separate legal fees from court decrees, which are owed for all manner of Kenyans.
Okay.
Number 2, there is an advocate's remuneration order that sets standards for legal fees. And there is a system of assessing legal fees. And when one disagrees with the assessment, you actually go to court. And there is a court officer, a deputy registrar of the High Court, who assesses the fees based on the remuneration order, listens to both parties. So this is a very fair process. You know, there are other professionals.
Do you agree that there are lawyers who, in some instances,
yes,
charge over and above what is required?
That was now the 3rd point I was going to make. Despite these safeguards, we know that there are always situations where there is abuse of procurement, there's corruption, there's overcharging. In some cases, there's inflated bills, not only legal fees, engineering fees, accountancy fees, construction fees, everything in the country. And in some cases, it has happened that kickbacks have been organized, whether it is involving a lawyer or an engineer or someone else in public sector. So there are some rotten apples and some unfortunate cases, but they have to be dealt with on a case-by-case basis without condemning everyone in the legal profession or giving the impression that there's a problem with the legal profession as opposed to other professions. There are problems in the legal profession like other professions in issues of corruption, procurement, accountability. It's a problem we are having as Kenyans.
Okay.
But it's not a problem that is unique to the legal profession. In fact, the legal profession has unique safeguards to evaluate and assess the fees that should be charged by lawyers.
Okay, and thank you, Senior Counsel, for setting the stage for that conversation. We've seen this debate, and especially counties have come under a lot of scrutiny, a lot of criticism on how much they're spending as legal fees. This is part of the problem that we have when it comes to pending bills, that they pay a lot of money to lawyers and they're not able to pay for anything else. Do you get where the Senior Counsel is coming from?
I actually want to agree with Senior Counsel on that because he will give the perspective as a lawyer, but looking at it from a common man's perspective, a taxpayer, a normal Kenyan citizen, I would think that it's like the government, both levels, would be trying to avoid taking responsibility for the money that is lost. Because under normal circumstances, procurement happens across the government and even private entities. If today this corporate where we are in decides to buy a machine or two, they will put it out there that we are looking for this, our prices are this, or we want people to bid, and then out of that bid, we will pick someone who is giving us the quality we want with the most competitive price. So why is this not happening when it comes to legal fees? What we are seeing is we have spent, like IBC that you've mentioned, we have spent this amount of money on legal fees. And that money sounds so huge after elections. And now the question that some of us ask, for example, the election of 2017, which I'm not sure if Wakili Harrison was part of the legal council. And
I think I saw him on TV somewhere.
You saw him on TV, I think I also did. So you realize that at the end of the day, the Supreme Court of Kenya, of the Republic of Kenya, tells us this election was not conducted in accordance with the law. But after that, no one tells us who takes that responsibility, because the IBC chair and the entire commission goes home happy, and 50 billion has been spent in that election, and the Supreme Court lawyers have argued, and the Supreme Court have a verdict that somebody decided not to conduct election in accordance with the law. But that somebody is not told to the Kenyans. Who is that somebody? Because he is supposed to, in any other circumstance, that person is the one who is supposed to pay those legal fees. Because when Wakili Kanjama takes me to court and the court awards him, he wins the case, I am supposed to pay those legal fees and everything that is involved. But here, Kenyans spent money on election. It is taken to court. The highest court of the land says it was not conducted in accordance with the law. IBC had lawyers. So who actually took the whole election outside the legal framework? That is the person who is supposed to pay that amount. But then we are left like that. We are just told we are going back for another election. So I think government are trying to run away from some of their excesses and putting it on
this is
lawyers,
definitely one
on the legal fraternity to actually be the one looking in the eyes of Kenyans as the ones who have messed up the monies.
Let's welcome Wakili Kinyanjui to this conversation. Wakili, I think the debate now is focusing on why is it that lawyers get to set their own fees? The Senior Counsel says that there are standards provided for on how much you should charge. But it would appear, while other professions, engineers, accountants, they have to bid through procurement processes and the price probably is set. Why do lawyers get to give what they should earn?
Thank you very much. Let me begin by saying that the freedom to contract, just like Kanjama has said, the government at both levels is free to contract, to engage the best. Just like he said, there may be problems at the procurement level. But, and however, that does not take away from the fact that a lawyer who does what they have been engaged by either the national government or the county government to execute as per the agreed terms, then of course they have to be paid. So what Kanjama didn't expand on is that there are two ways of remunerating, paying the lawyer. You have the client-advocate agreement, fee agreement, that for this work, I'm going to be charging this amount of money. So they agree, that's a fee agreement, that the advocate fee agreement. And that is dealt with separately and different from the remuneration order that Kanjama mentioned about. The second way is through that remuneration order. It is set that if you do this sort of work in Nyeri, if you do this sort of work in Mandera, for instance, it's the same. It has to be the same. So that is a scale that lawyers ought to follow when there is no fee agreement. So perhaps some of these questionable legal payments arise from that sort of arrangement. But let's not pussyfoot around the issue of corruption. These governors have become terrible persons morally and even at that level of financial probity. They use lawyers. It's known. Let me use the example of Lawyer A. Lawyer A is engaged by a county government. He is friends with the governor, and the governor tells him, this brief I'll send to you so that you charge 100 million, so you will give me 50 million, and you will give the CEC for finance 10 million, and blah, blah. The lawyer ends up with maybe 5 or 10 million. They're in cahoots. Now that lawyer will not deliver. Often that lawyer will do shoddy work, and in turn, the county government will lose.
No money.
Because they will lose a case. If they lose a case, which probably was good, and the county should have won, then the county is heaped on with a heavier burden. So what are we saying? Some of, just like Kanjama said, not all, some of these lawyers, they are engaged solely for purposes of being conduits of corruption. It's in black and white. But no one wants to unmask that. And then,
not even the Law Society.
But the Law Society has to have a complainant. Remember that. The complainant here ought to be the national government or, in fact, the county government. But what does the Auditor General do? The Auditor General generates a report, takes it to Parliament. Parliament does not even interrogate those because some of them are also in cahoots with that, and I'm not saying everyone in the National Assembly. But you can see now, the engagement is solely for purposes of corruption. It is cloaked as legal representation, whatever. And just like Odere has said, some of them will appear in court to defend the indefensible. And they get hefty fees for that. They are my colleagues, but it is happening. And the moment that Kenyans know that they're not getting value for money, but they're actually being dished out with cloaked and actually camouflage corruption, that is a time that we will say, no, it cannot happen. Let some of these governors be put to task. When the Auditor General appears, generates a report and says, the county government of Nairobi is asking for 2 billion or 10 billion in legal fees. Why?
Isn't that enough, the auditor's report, enough for the Law Society to take action? That's
Let me finish the point. So the Auditor General has pinpointed A and B and C cases. At the National Assembly, when that interrogation is done, those people ought to be summoned together with that financial officer or whoever responsible officer is from the county level. Now, having said that, Kanjama said something which is remarkably overlooked, that both the national government and the county government are handicapped in terms of proficient legal representation. And the state often loses cases that it ought not to be losing because of that lack of expertise. Lastly, when there is collusion between these lawyers hired by the county government or the state with the other side, they enter into agreements which now bind the court. And you ask the court, why did you enter this sort of judgment for against? I mean, it's indefensible. So the judge says they filed a consent. They agreed, and the judge or the magistrate then can do nothing. When you hear someone is being paid 1 billion in legal fee or 8 billion or whatever money being paid in legal fee because there is a consent, there is an agreement that ties the court. The court, obviously, the moral property comes in, engages the judge or the magistrate who says, wait a minute, this can't be. It's against the remuneration order. But both sides have agreed.
Isn't there where the law society comes in? When you come to check the morality and ethics of these lawyers, because you have the power to, and you're gunning for that position as the president.
Yes. I think, again, I would say there are three things I would like to say. One, I fully agree with Harrison that there are cases of collusion where corruption happens, where there's procurement misconduct, and sometimes state officers may be colluding with specific lawyers to inflate legal fees so that they can get a cut, and sometimes it's even the lion's share. That is actually quite unfortunate. It's happening. I don't want to say it's happening in majority of cases, but it's happening in some cases. Number two, when this happens, we have to rely on investigative agencies to unmask the fraud or corruption, like in any other sector or in any other transaction. These include Ethics Anti-Corruption Commission, sometimes the DCI. Parliament itself has ability to supervise, and when they receive reports from the Auditor General, Parliament can call for further investigations, can summon witnesses. So number two, this is what is meant to happen. Number three, for the Law Society of Kenya, we have a structure that includes the Advocates Complaints Commission, where people can lodge specific complaints against specific advocates for specific transactions. You can't tar the whole profession. You can't tar all the people providing services to, for example, a particular state agency. You have to be specific, because there is a right of fair hearing, there is a right of fair administrative action. Advocates Complaints Commission can do certain kinds of investigations, and then you can lodge complaints against any specific advocate who's accused of misconduct at the Advocates Disciplinary Tribunal. And you can even take the case directly to the High Court to ask the Law Society of Kenya to do that one, while there's meant to be some independence between the investigative process and LSK itself, is to confuse the roles of the two organizations. So LSK, what it can do is it can sensitize its members about the need for them to act ethically, to act with integrity. We have standards of professional practice and ethical conduct that all lawyers are meant to adhere to. We can train them on it, we can do all that, but when a specific instance of corruption comes in, then you have to refer to the organs that are within the Advocates Act and the LSK Act that have the ability to investigate and deal with the matter. And then you also have other organs in the Constitution, like the judiciary and the Ethics Anti-Corruption Commission, that can also engage in those specific instances.
All right. These are headlines we're looking at on page 10 of the Standard Matters. Legal fees and the government entities seeking and procuring private legal advice and legal representation. So there's a legal storm. A state hires private lawyers in 5 trillion shilling fund case. And the risk here is some of these lawyers negotiate on percentages based on the principal amount. When you're talking about 5 trillion shilling fund, I don't know how much you would charge to represent any person on that matter. Meanwhile, the Law Society of Kenya is fighting an order which is blocking the hiring of private firms by state agencies. Those two are related, and it is what we were seeking clarification from Charles Kanjama, who's senior counsel and is gunning for the position of president of the Law Society of Kenya. We wish you all the best.
Thank you.
Let's take a short break. When we come back, we delve into what is on the front page of The Star.